My Lord, I will be so brief.
Said that avoid repetition.
Yes,
We
ma'am.
are not keep rotating on the same grounds.
Yes, ma'am.
Kindly, I think, let us restrict on the point that has not been raised by another advocate. For the interest of time.
Much obliged, my Lord.
This is counsel.
Luyimbazi Nalukoola. My Lord, I will not consume a lot of time, but rather only 2 minutes. My Lord, you have a simple task today, only to implement a constitutional commandment. Which is provided for under Article 23, Clause 6, C. My Lord, the provision is in respect of actual bail. Our application, my Lord, is not for a discretionary bail. And indeed, my Lord, the bail we are seeking, today the applicants are not here for a right to apply for bail. But rather to receive a bail, my Lord. That provision was deliberate and intentional by the framers of the Constitution of 1995. Deliberate and intentional. It was premised on, among others, the oppressive and imprisonment without trial, which was characterized, I beg your pardon, which characterized our political history, my Lord. My Lord, denial of the right to a mandatory bail by the applicants now before you will be so detrimental to the values and wishes the framers of the 1995 Constitution intended to achieve, my Lord. My Lord, I invite you, my Lord, to stand tall over the unsubstantiated allegations advanced by the state. To persuade you not to grant the application, my Lord. My Lord, I beg to rest.
My Lord, I have only one or two things to say. Firstly, to reject the proposition in the paragraph 17 of the respondent's affidavit that the applicants have only spent 167 days. We just want to emphasize that there is only one state, and that is the state of Uganda.
And since they have been on the since that they have been in remand for only
167 days. They deliberately refused to account for the period between 20th of November 2024 and 20th February 2025. They admit that period in their affidavit, but they refuse to account for it. And I've said there is only one state, and it is the state of Uganda that was holding them between that period, which is 90 days. So if you add 90 days to the admitted 167 days, that's a whooping 257. But if we count up to today, it's 263, as indicated by my colleague, Arias Ukwa. You have the final word. Count the dates from actually the date of arrest. The date of arrest or abduction in Kenya by Ugandan military in league with the Kenyan military. That matter is subject of a case in the courts of Kenya. The other point, you have been told that the applicants, the first applicant, has been in many cases. What the prosecution is saying, this is in paragraph 18, they even cite an existing case, which is case number 624 of 2023. Kindly note, my lord, they are not talking of convictions. They are talking of prosecutions they have mounted against him without securing a single conviction. Prosecutions designed to keep the first applicant in custody, just like in this case. You can only quote previous antecedents when a court has pronounced itself and there is a conviction. For the case that is pending before the Nakawa Court, 624 of 2023 criminal case, the prosecution cannot have their cake and eat it. Why have they not concluded the prosecution since 2023? You come to cite a case where again you are guilty of laches. The associates who are accused of singing are not named, nor are tapes of what he finds, the music that he finds not good, not so melodious to his ears. So it's a mere allegation. And what if others have sung? Are these two applicants going to be punished because others have sung? We are asking the court to ignore. Finally,
Aaron Chiza, also counsel for the applicants, and I will continue and reiterate the earnest plea of the applicants that they be admitted to mandatory bail I will add a few clarifications. One such clarification, Your Lordship, is to clarify the nature of arrest. That on 16th of November of 2024, what happened on 16th of November 2024, what happened in Nairobi, Kenya, to the applicants who were going for a book launch of Honorable Karwa Martha was not a mere or ordinary arrest. It was an abduction. So before you, Your Lordship, are victims of abduction. That is contained in paragraph 5 of the affidavit of the first applicant in support of the mandatory bail application, paragraph 5. Your Lordship, before they were remanded and following their abduction from a foreign capital, they were subjected to incommunicado military detention. They were subjected to incommunicado military detention at the Machindi military barracks in Kampala, Uganda. That took for 4 days, 4 clear days. And you are in between 16th of November to 20th of November the same year, 2024. Before we go very far, this has legal implications because, first of all, incommunicado detention is unconstitutional and is a violation of personal liberty. That Article 23 seeks to protect. But even more poignantly, Your Lordship, according to our law and specifically the second schedule of the 2012 Prohibition and Prevention of Torture Act, Item 2, subparagraph 3, incommunicado detention is a form of mental or psychological torture. So, yet again, before you, Your Lordship, are 2 victims of psychological torture visited on them by Uganda People's Defense Forces. Of course, torture is a crime. And in this incident, the scene of crime is Machindi military barracks, Your Lordship. So after enduring torture and abduction, as I have adumbrated above, on the 20th of November 2024, the applicants before you were arraigned. They were arraigned before a kangaroo military tribunal. They were arraigned before a kangaroo military tribunal. That military tribunal was at Machinde. It is like 1 kilometer away from the scene of crime of incommunicado, torturous incommunicado detention. They have never been free since then, Your Lordship. They have never been free. And that's why they are coming before you. And those facts, I must emphasize, are not mine. They are contained in paragraphs 4 and 5. Signed sworn statement of the first applicant, paragraphs 4 and 5. Your Honor, the duty of releasing the applicants from on account of mandatory bail rests primarily the court.
My Lord, just a moment. I think this is just overwhelming court review.
Come again?
My colleague is simply overwhelming court review.
Let him conclude. You have the right to go ahead.
Most of that. So, before I was rudely interrupted, Your Lordship, by the cantankerous Richard Birivumbuka, I was developing a thought to the fact that even if the applicant has not applied, even if the applicant has actually not applied, that's not a prerequisite for mandatory bail. The application for mandatory bail is not a prerequisite for mandatory bail. The prerequisite for mandatory bail is the effluxion. The effluxion of 180 days for capital offenses. It's not an application. It behoves the judiciary, but specifically the trial magistrate, one, to count the days, to be aware of how many days the accused before that person has spent on remand, and as soon as they clock 180 days in the case of capital offenses, pursuant to section 76 that has already been alluded to of the Magistrates Court Act, the magistrate can simply release. It is as simple as that, although some people want to complicate it. Now, Your Lordship, if the magistrate does not want to release the applicant following the parent law, there is subsidiary law, or the bail guidelines. Because for me, there should be no debate between a conflict between parent law and subsidiary. But in case the magistrate has any doubt about what to do, they should follow regulations 10 of the bail guidelines and immediately refer the file to the High Court. And once that file is referred, again in sub-regulation 11, the registrar of the High Court or of the criminal court to which the matters are referred is obliged, is not requested, is obliged by the bail guidelines to schedule them and of course mindful that the court should resolve the matter within 30 days. The reason the magistrate is assumed to know the remand days because every remand, Your Lordship, happens under the remand warrant. Every remand happens under the remand warrant of a judicial officer and before committal specifically of a magistrate. Your Lordship, a magistrate cannot feign ignorance that somehow I did not know that the applicant before me, the accused before me, has not spent 180 days, because every mention they have to be aware of how many days. But the accused person has spent on remand before further committing them on remand. Your Honor, it is the argument of the state that they are about chance. The reason they're objecting, one of the reasons they're objecting to the mandatory bail, which is an unconstitutional reason, of course, is chance, press conferences, and yes, chance and press conferences. I want to say that those are constitutionally protected rights under Article 29. And a thorough reading of Clause 1, Article 29, would preclude the state from citing it as a ground for objection. A related objection, Your Lordship, is that it is in paragraph 29, I think, of the reply, of the state's reply, and it says that that the accused is of a high profile. Paragraph 29 of the affidavit of Kukundakwe Kusinje. The reason is that the accused are high profile, influential, and command a big following. Your Lordship, few statements are astounding as this in the journey of a legal profession. So you are being invited on record in writing, Your Lordship, that you stop the bail, the liberty of the accused, simply because they are high profile, influential in society, and command a big following, and they have the audacity of including this in the sworn testimony and filing it on the record of the High Court. Your Lordship, high profile, popularity is not a ground for denial of liberty, even if it were not mandatory bail. I think it is irregular for the state to be envious of the accused. The point of liberty has been succinctly clarified, but one of the fundamental points of mandatory bail is actually to stop trial without detention. Detention without trial. And these are not my own words, Your Lordship. These are the words of the Constitution. And the Constitution adumbrates them in Article 43. The twin purpose is prevention of political persecution. Again, Article 43 succinctly and expressly outlines that. It is a factual reality that the accused are being politically persecuted. although it goes without saying, the accused have taken the trouble to outline it in paragraph 3, or rather paragraph 13, I beg your pardon, paragraph 13 of their affidavit. Paragraph 13 of their affidavit talks very clearly about the political persecution that the accused have had to endure. Your Lordship, I will end by clarifying the issue of mandatory bail, especially the fact that I want to clarify, one, there was a transfer of charges. This followed a Supreme Court decision. And unless the state is saying that it defied the Supreme Court decision and it did not transfer the charges, but of course, the facts would betray them. Your Lordship, what changed was only the courts. The fact of remand itself has never changed. Howsoever framed, the charges that were in the court martial are still here by order of the Constitutional Court. The idea is that the facts are the same, have not changed, and the law is on the principle of legality and double jeopardy does not allow. It's not even that the state can now introduce new facts. The state, the law on the principle of legality and prohibition of double jeopardy, that's contained in Article 28 of the Constitution on fair hearing, does not allow twisting facts so that on the basis of the same fact you bring a multiple of charges. You keep tinkering with the legal nature of charges while you're using the same fact. That is not allowed, and in any event it would have been prohibited by the express order of the Constitutional Court. So the accused or the applicants have been remanded by 4 courts. The first court to remand them was the Kangaroo Military Tribunal on 20th of November 2024. Following the Supreme Court judgment, the applicants made an application to the High Court Civil Division for habeas corpus. They came and they argued it, and on one of the questions they argued it, I was there, even though I was still yes. So they were remanded by that court even before their ruling on habeas corpus could be given. Then they were remanded by a magistrate's court in Nakawa, and then they were remanded by the criminal court, the criminal division here. That is just for clarity. Most obliged, I will yield the floor to my colleagues to address other issues.